and welcome to Legal Affairs. My name is Diamond Liddy, and I'm the public defender of the 19th Judicial Circuit. We are kicking off this year with a great topic and a great guest, Kevin Hendrickson, who I've known for 100 years. Yeah. And we're going to be talking about wills, probate, elder law, something that is touches us all, hopefully, at some time or another. And anyway, welcome, Kevin. How are you?
Thank you. Good, good.
Okay. Before I get to, I have so many questions. Before I get to that, tell us about yourself.
Well, I'm board certified in wills, trusts, and estates, and board certified in elder law. And I also have passed the certified elder law exam for ABA accredited for the National Elder Law Foundation. So my practice is limited to wills, trusts, estates, and elder law, and
Wow.
that's what it is. I have basically foregone and gave up any sort of guardianship because that
Okay.
I used to do guardianships,
Right.
but it's become such a it's a new marital law as far as that goes. People are very contentious when it comes to that. So
Really?
you try and avoid, if you can, guardianship, but that's a separate issue altogether. I can discuss that as well too.
Sure.
Okay.
And how long have you been doing this?
Oh, I've been doing this since, well, I was the state attorney. That's where I met you, and then afterwards I went with Phillips and Gale, and then Roman, Bruni, and Angeles. In 1992, I went out on my own, and basically I gravitated to this area and took the necessary exams to pass it and so on of that sort. So I've been practicing in this area since 1992.
Wow. So, well, and that's when I got elected, so
yeah,
it's been a long time. Okay, let's just talk basics, because some people don't know the difference, and they hear things. What is a will? What is probate? And what's the difference between that and elder law?
All a will is a written direction of how you want to leave your assets. It does not avoid probate. I have people coming in, well, I have a will. I don't have to go to the probate. It says, well, it all depends upon how you have your assets titled. And a will is nothing more than a written direction.
Right.
But it has to be in writing in Florida and in most states. You can't have an oral will.
Right.
Because that could be, there's no way that you can determine if that's valid or not.
Right.
But it has to be witnessed by two people. It doesn't have to be notarized. If it's notarized, then it's self-proving. It can still be a written document witnessed by two people. But the problem is that a lot of times people go ahead and do their own wills, and invariably they think if it's signed by one person, that's all you need to do. Or if they have it done, then what happens then so often, they don't think they have to do anything further. They think a will guarantees I won't go to probate because it's right there. I can take the will down to a bank and they're going to go ahead and accept what it says that it goes to my daughter.
Right. Stop. Now, what is probate?
All right.
Okay.
That took me a long time because in law school, probate is basically it's a method in which you prove how you're going to leave the assets.
Okay.
So what probate is this. You can avoid probate by certain things. For instance, if you have a life insurance, typically a life insurance or an IRA, life insurance, you can name a beneficiary to that life insurance.
Right.
So you could have theoretically a $500,000 life insurance, and if you name somebody as the beneficiary, you could have the will that has something separate that leaves all my assets to so-and-so. But if your life insurance has a beneficiary, it goes to that beneficiary. It does not go to probate.
Okay.
Well, let's say this. Let's say you just name one beneficiary, and that beneficiary predeceases you, and you didn't name a backup or a contingent. Guess what? Then once you die, then that becomes an asset that will have to follow how the will goes.
I gotcha.
And then you're going to have to go to court. Now, you can't, like people a lot of times, well, I'll just go ahead and do it myself. No, that doesn't work because
right.
so often individuals don't know what they're doing when they do that. Now, certain states allow them to do it. So you hire an attorney, and hopefully they have the necessary elements to do it. But the problem is that a lot of times attorneys can do anything once you have a law degree. You can, like for instance, I'm an attorney, they could come to me and says, would you represent me in a first degree murder case? Absolutely not.
Yeah.
Technically, I could, but that would be, I'm basically committing
Right.
my
Talk about malpractice.
practice.
Well, because you haven't, not because you're not a great lawyer, but because you haven't done it for a long time.
And lawyers
right?
specialize in certain areas. So to get back to the probate issue is that if you have a will and the will says I'm leaving everything to so-and-so, then that life
Prevails.
insurance would then
But-
be
Right.
a necessary item that you would have to bring in. Now what happens when you hire an attorney, then creditor claims can be filed against the estate. You may have a creditor out there for, let's say, credit cards. You may have medical bills or, loans outstanding. They can then go after the assets. And then you have the attorney fees.
Right.
Now, I want to go ahead and clarify certain things. In Florida, we have an estate tax and a gift tax. We don't have any inheritance tax. But
Wow. See, I'm learning. I did not know that either.
the estate tax, generally speaking, they're not going to go ahead and the present administration going into power, the Trump administration, is going to extend the tax cuts. So basically, I said, is your estate over $12 million? And generally speaking, if it's not, you don't have an estate tax to worry about. I won't get into the particulars about
And that's the cutoff, 12 million?
12 million for a couple. But then if you're married, you can leave an unlimited marital deduction to the survivor. But then if you do that, you waste a unified credit. But that's getting into more detail.
Yeah, right.
If you're single, it's around 6 million, 6.5 right now. And that's going to be inflation adjusted and so on. So most people that I've come in contact with don't have that as an issue.
Right.
So their biggest danger is probate. And you say, what does that mean? I have a will, won't that take care of it? No, it doesn't, unless you have beneficiary designations. But the problem you have is that you have a lot of times individuals that have second and third marriages. And then you have stepchildren coming in. And then you have to be sensitive, because if you own everything together, husband and wife,
Right.
as let's say your home, then if you die, it's going to go to the surviving spouse. And a lot of times they say, well, I want that home to be split between your children and my children.
Right.
And that gets into issues, because technically, if your name's on the home, like husband and wife, then it goes by operation law to the survivor. So it doesn't go through probate. But in my will, it says that he's, if he dies, I'm supposed to split it. Doesn't work that way. So in that situation, a lot of times when husband and wives own things together, whoever survives wins the whole pot.
Yeah.
And no matter,
Regardless
of what your will may say, would
Right.
you say, I leave everything to my spouse, then upon our deaths, we're going to divide it between his children and my children equally. Well, I always tell them, whoever wins is going to, and usually it's going to be the female.
Whoever outlives.
Because the females live longer than the males by 6 or 7 years. So,
And you would know that. That's so funny. But I'm sure, I know you're right.
But when you get into, let's say, IRAs, you name beneficiaries, and I get, you name a primary beneficiary and a contingent beneficiary. So you can avoid probate on that, for instance. Like if you have an IRA and you have a $300,000 or $400,000, you can name your spouse, and then if that person predeceases, then you name a contingent. It could be your children.
Right.
No probate. They would then contact the financial advisor,
right.
and they would fill out the necessary paperwork. You could also do it with brokerage accounts. Let's say if you have your own, either Fidelity or
Right.
a discount broker, and you have husband and wife, you can have what they call is payable on death, POD, payable on death, and name the children, and that avoids probate. And that means then upon the last of you to die, whatever's in there
Goes to
them
automatically
outside of probate.
Okay, I want to stop you. Basic question. What's the downside of it going through probate?
The downside then is this: it's subject to creditor claims.
Oh, okay.
And guess what? It's also then you've got the attorneys coming in.
Yeah.
And I've seen attorney fees, and I can understand why people are concerned. I've seen it where 3%, they can even go higher depending upon if there's litigation and things of this sort. And then they say, well, I'll go ahead, and then what we can do is we'll go ahead and put everything into a trust. And I hear this all the time. People want a trust, and I say, a trust doesn't guarantee. They think a trust is going to go ahead and protect them from creditors. It's not. Trusts are either revocable, they can be changed or amended, or irrevocable. you basically, when you have an irrevocable trust, you're giving all your ownership interests in that property away. Do you really want to do that? And they say, what does that mean? Can't I get it? No. Once you make a gift, you can't get it back. So when you put it into a revocable trust, in Florida, there's a 2-year statute of limitations for the trustee to be accountable to any creditors. And a lot of times people don't realize that. And when you have it in a trust, if someone passes away, whatever's in that trust, that becomes irrevocable. You're going to have to get an EIN number, employer identification number,
Right.
and the trustee's appointed, and then they have to do an accounting for whatever's in there to the beneficiaries, and that always creates an issue.
Yeah.
And a lot of times people have trust, and I ask them, what do you have? Well, we have a bank account that's $50,000. I went, okay, we have a home, and then we have IRAs. I says, why do you have a trust?
Yeah.
And they say, well, we were advised to put our home in the trust. I says, why would you?
Yeah, let's talk about the house issue.
Why would you put your home in that? Well, that way it avoids probate. And it says, well, there's other ways that you can avoid probate. If it's, I'm just going to talk to a regular mom and pop, been married for years, and they have 2 children, and they go ahead and they put the home in a trust, and it's basically a homestead property. If it's their home, it's protected from creditor claims already. But you can avoid.
Not in all states.
Not
in
all
Florida.
states, just in Florida.
Right.
And if your home is on a ½ acre or less in the municipality in a city, it's fully protected.
Wow.
And if it's in the county, you can protect up to 160 acres. And just generally speaking, I'm not going to get into the nuances.
No, I
But when you put the home into a trust, then it's just not a simple matter they can just deed it out, because now what you have to do, if the title's been in the trust, then you have to, you're going to have to get an attorney. They're going to have to then prepare a trustee deed to distribute the property out of the trust to the children, and then the children said, I thought we could just do it. It belongs to us. It doesn't pass automatically because the title is in the trust, and then you have to then deed it out, and then you have to have a trustee or a successor trustee. And
so let me stop you right there. So the goal, I think, which, of course you want to make money as a lawyer, but your goal, based on the amount of assets, is, yes, they're there and they need your legal advice as a lawyer, but if there's a possibility that you can set it up where upon someone's death, they don't need more lawyers, that certainly is the goal.
Well, in a situation like this, let's say you have a husband and wife, they could do what they call is an enhanced life estate. But the vernacular is a ladybird deed, and basically what that is you're transferring the ownership of the property from the couple to themselves for their lifetime. But they still own it, they still have the rights to it and everything else, and if they get upset with the children, they can deed it back to themselves. But then they put down upon the last of them to pass away, the ownership interest vests in my 2 children, A and B. Let's say both parents pass away, then the home then vests in the 2 children. They get a step up in basis, which means there's no capital gains. It's valued on date of death. But then they're going to have an increase in property taxes and so on.
Sure.
But then they own it, and they own it outright.
Right.
Now, this is always subject to an understanding that a lot of times, and this is unique in Florida. I mean, Florida is one of 9 states that have this enhanced life estate, or like a ladybird deed. I don't know why they call it ladybird. It's not from Lady Bird Johnson. And other states don't recognize it. But it's something that is not, I don't go ahead and just use it randomly. It's where someone's approaching the end of their lives and they want to avoid probate, and they're thinking, what do I need to do? Well, this is one simple way of doing it, but it gets complicated when you have mixed marriages.
Well, the stepchildren thing is
then,
you
can't just make a whole litany of all this. But, just taking the simple example I said about a person that wanted to have a trust and put the home in there, they could have easily done something a little bit more practical, putting the 2 children on. But if something happens to one of the children and they predecease the parents, they need then to redeed it back to themselves just to their one surviving child.
Right.
These are things that they can do, and a lot of them try and go out and do this themselves. And invariably, when you do your own legal work, something's going to go wrong.
Right.
I mean, I'll give an example. A lot of times people will go ahead and they'll make their own deed up, and they'll just take it from the property appraiser's screen,
right.
and it's not a complete legal description. And then they put themselves down as A and B, and they say, well, it's going to go to the survivor. Unless you put as joint tenants with rights of survivorship, it's not going to go that way. It's going to be presumed as tenants in common. So going back to the example of that couple that put everything in a trust, their IRA doesn't go into a trust. Your name doesn't go in trust. What you're doing is you're naming the beneficiary of the IRA, the beneficiary as a trust.
Right.
And that's like, why would you do that if you can just name your 2 children? It goes directly to them. Instead, if you name the trust, then it has to go from
The trust
life into the
to trust.
And
Yeah.
it's like, you just complicated things, and it wasn't that necessary. And then, let's say on the bank account or bank accounts, you know, you could have named
Yeah.
the beneficiaries.
I was going to say, you
That's
can,
it.
yeah, you just put that on the, okay, and it's simple.
It's simple.
But, okay,
But let me just take another thing. You got these people that always come in, and let's say they set up a great, wonderful estate plan. They have this
Right.
trust. I see it come in, and it's this nice big booklet, and I'm like, and they have all this stuff and the durable power of attorneys I can get into. And then all of a sudden, they come in and says, my wife just had a stroke, or my husband had a stroke.
Right.
And I have a problem. So what? I can't take care of him at home. We can get Medicare to do that, can't we? It says, no, it's not going to happen. You're not going to get government assistance to come in the home. You have to apply for Medicaid. Medicaid is welfare. And if you have too much assets, it's going to impair what your eligibility is.
oh boy,
So
wow.
you may have gone to an estate planning, but they're not going to necessarily advise you what may happen on these contingencies. So you're going from here to here, so when you set up an estate plan, it's designed to take place if and when you pass away, ideally. And then your journey is going to be uninterrupted.
Yeah, but that doesn't always happen. Exactly.
So if
Yeah.
something happens and someone's like has to go into a skilled nursing or assisted living, then their assets, depending upon what the situation is, are subject to being attached and could be. The one thing I hear a lot, they think that your home, they can put a lien on your home and take your home for Medicaid.
Right.
They cannot.
Cannot, yeah.
I hear it all, even from people coming in, or attorneys in nursing homes advising people, no, they can't.
Yeah.
Home is a protected asset in the state of Florida. Now, it's homesteaded, but you can still establish it if you've been in there, even though you don't have the homestead exemption, if you've
Right.
established it. And
Oh, that's interesting.
yeah, a lot of times people, for whatever reason,
Whoa,
they haven't
okay.
been qualified to get the $25,000 or $50,000 exemption, but they've been living in there for years, and they can still establish that
it's
is your home.
Okay.
Right? But then you'd have to get an argument to establish all that. But that can be done. But the way it works in Florida is unique. Half acre or less in a municipality, a city, is exempted. Up to 160 acres is exempted if it's your home. Now, if you own property as husband and wife, that's going to be what they call tenancy by the entirety, which is nothing more than joint tenancy with rights of survivorship between husband and wife.
Right.
States like South Carolina do not recognize that. So you'd have to go through probate unless you state the language as joint tenants or rights of
Wow.
survivorship. So when you see a deed in Florida, it maybe say John Doe and Jane Doe, his wife, that's tenancy by the entirety.
And it's good.
It's good, and it'll
Yeah.
go to the survivor. So, but those are the issues. But a lot of times people aren't aware of that because they think when they develop their plan, everything's fine. And
Well, they've either
And
done
they-
it
yeah,
themselves,
exactly.
or they've gone to an attorney who does murder cases and just needs to pay the rent, and they don't know what they're doing, and all of a sudden,
I see
yeah.
a lot of times in which they don't really think about all this until something happens.
Yeah, yeah.
And they have necessary documents, you know, they think all he needs is a will, but they've failed to understand that, excuse me, you need a durable power of attorney, health care, surrogate, and living will. So I've seen a lot of times, 1 or 2 page document that says this is a durable power of attorney, it's not going to fly. It may fly maybe for your bank, but if you have to use it for financial institutions, or if you're applying for Medicaid to get things, it's not going to work, because you have to have certain language in there now, and the durable power of attorneys have to have these superpowers. You have to initial them, and these are things that you can go to an attorney, and a lot of times I've seen where, for instance, on Medicaid, which is, like I said, we're getting to planning in a nursing home or assisted living.
Right. But
you got to have the language that says you can create qualified income trust. These are issues. Now, you may address that with the estate planner, but they may not have the expertise or.
Right.
So I compare elder law and wills, trusts, and estates as the flip side of the same coin. And that's why I viewed it important to know both
things,
because you can't advise them otherwise. And so it's really a dilemma, because sometimes they have this wonderful, elegant estate plan, and now you've got to unravel it to protect the assets for the one that needs the assistance.
Right, right. Wow. No, I mean, that's a great overview of the, but I mean, there's so much to this. Now, do you do any, let's back up. Do you get involved in contested wills and that kind of thing?
I have done that, and that becomes very ugly.
Yeah.
Yes. And I recently settled one, but it becomes ugly. And we had one in which, just as an example.
And I mean, you go to court, it's a trial.
It's a trial,
just like,
but you try and settle it. They always want to settle cases.
Right, right.
Because it can clog the system. This was presented to me, and I didn't realize it. They did a will. She signed it the same day she died. I went, but what happened was they brought in 2 individuals, a notary and a witness, and they prepared it, or somebody had prepared this will. And then the lady signed it. But it was chicken scratch. And I spoke to the notary and her witness, and it wasn't self-proving, which meant both signed as a witness, and then the notary notarized her own witness.
Right.
So it didn't, but it was a valid will, depending upon what was said and so on.
Right.
So all you need for a will to make it valid is a lucid interval. It's sort of like the eye of a hurricane.
Right.
They can be bad forever. I didn't mean to say that.
No, that's
but it's like the eye of a hurricane. As long as that one temporary moment, they are clear on who they're wanting to leave it to.
Yeah, but how are you ever going to prove
it? Is so difficult, because the suggestion is they didn't know what they were doing.
Right.
So what happened was I spoke to both of them. The notary who came in, and she said she read it and so on, and the woman was agreeing to it. And I says, was there anyone else in the room and so on? And she said, well, her brother was there. And the brother was able to testify.
Right.
He wasn't in the will.
Oh, he wasn't.
Was
so
not,
it would
and
be,
he spoke to his sister, and sister says, do you understand what you're signing? This is it. And she said, yes. And who do you want to leave it to? And then she said who it was. But we had a contested matter. We settled it in mediation.
Yeah.
And basically,
thank goodness for mediation. Yeah.
And it did work. It was effective, because it was like 2 people going at each other, and it became expensive. And it's like,
well, and then all of a sudden, all the assets in the will are gone to pay attorney, which, you know, that's...
It happens, and that's why certain things, you know, and then you'll have, you know, certain attorneys that have said to me, said, you know, we'll go ahead and file suit just to work out a settlement. That way I can get paid and so on like that.
Right.
Says, well, what are you talking about?
Yeah, let's try to mediate it.
That and so on. But those are things that you try and avoid any way you can. And you try and tell that to certain people. And they're receptive, but they don't understand, well, why won't they accept it? But those are the issues that you see a lot of times.
Now, do you ever get involved in what's called a prenuptial agreement with what you do?
That's a good point.
Which is and believe it or not, we've got like 4 minutes left. I know there's. I can say this.
I do not do the prenup agreements, and I'll tell you why. Because usually there'll be two people coming in.
And let's define them first. A prenup is a signed agreement when people are getting married to do certain things,
Exactly.
not not ask for any of the assets if they get divorced, whatever. Okay.
Sort of like what Donald Trump would do before, and he did that.
Right, right.
And the prenup agreement in Florida, you don't have to reveal your assets. A postnup agreement, you do have to reveal all your assets, both sides.
Wow, I did not realize that either.
What you need to do is sometimes these attorneys, one attorney will prepare the prenup for both parties. Wrong. Even if they get along, you've got to get an attorney for one party and another one, so that if there is a conflict, that one, you're not the party, and if you have talked to both of them,
it's like a conflict in a criminal case.
Conflict,
right.
Void, they go to separate attorneys, then they have a meeting of the minds, because that will be an issue later that they can't say, well, the attorney did it for both. And I had actually something like that to happen. An attorney did draw up one, and, well, I should say the client did, and he presented to his wife at the time they were going to get married, and the same day, and said, either sign this or we're not getting married. Oh my God. And it was something that was just, it happened.
Right, right.
And then a lot of times people don't recognize maybe you should do that, because then after they get married, somebody gets sick, and when you say, well, I have a house and it's always been my home, and then your husband moves in, guess what? You get divorced or you die, he has homestead rights to that.
Right.
You say, what? But that's non-marital. It says, not the home. So there's other issues. And the prenup agreements are they're important, but I don't do that. I let the marital attorneys do it.
Because you don't want to. It's
I don't want
too much.
And you don't do the same thing for the one. Like you don't do divorces for both of them.
Right, right.
And that's a good point, because
I am sure that in your line of work, Kevin, you have to see so much malpractice and so much,
the scariest part, Diamond, is where you're bringing in somebody, and I'm sitting across with the children, and they're promoting the agenda for their parent or someone, and I know this parent is not capable of understanding what's going on. So you say, well, I go to the seminar, you need to talk to the person outside of them. I can't even carry on a conversation with them, much less. And you're thinking, what can I do to help whatever we need to do? And that always puts, a conflict with the attorney and what's the best.
Well, it's an ethical issue for you.
Exactly.
I would think in your line of work there wouldn't be that many, but there are.
People give me a call and says, I need to have a durable power of attorney for my wife or my boyfriend or somebody. I say, well, are they capable of understanding anything? And then they, no, I don't think so. But can you still do it? I went, no.
Yeah,
I can't do it.
Okay, we are almost out of time. What is your 2-sentence advice for people in general?
Don't be your own attorney. Please, I don't build a house. I don't practice carpentry. I don't do plumbing, electrical. My wife likes to do that, but I don't do that.
So don't do it yourself.
Don't do it yourself. And if you're in doubt, seek out somebody's advice.
Got it.
Okay.
Thank you.
Thank you.